Legislative framework for psychologists. The New South Wales Mental Health Act of 2007 enshrined key principles such as that people are to be given the best treatment and care, and the treatment must aim to impose the least restriction to their freedom and the least interference with their dignity and rights. Secondly, the Act ensures that patients and members of the public are to be protected and minimizes adverse effects of mental health on family life. Thus, this Act provides provisions for voluntary patients and involuntary patients who must receive treatment for the community's well-being. Previous acts like the Mental Health Act of 1990 advocated for providing care to both mentally ill and criminal patients. An important concept to consider is informed consent, which is defined as when consumers of services provides permission for specific treatments. Individual persons need to be deemed capable to give informed consent, in that they must be able to understand, and thus special populations are harder to research since they are unable to give informed consent, such as children and the intellectually disabled. Informal admission is the voluntary hospitalization of mental health patients. Formal admission is forcing people to become involuntary patients who are detained, admitted to services, and accept treatment against their will. Usually, this is depicted as bringing mentally ill individuals into psych wards kicking and screaming. They have to meet a certain criterion that they are mentally ill persons with mental disorders. Individuals cannot be regarded as mentally ill if they have a certain political, religious position or are disabled, immoral, engage in illegal conduct, are sexually promiscuous, or identify with a certain sexual orientation. Just being different or engaging in unaccepted behavior does not constitute mental illness. This falls under human rights. Forensic patients are patients who are detained and admitted into hospital wards against their own will, resulting from a crime. Community Treatment Order, or CTO, are legal orders made by mental health review tribunals, qualified persons in hospitals or community-based services, or through the authority of a magistrate. CTOs are valid for 12 months, and they set out terms under which the individual must accept therapy, rehabilitation, and medication. These orders help to enforce regular taking of treatment and medication for those who are currently mentally ill or who are not, but are at risk of redeveloping the mental illness in 3 months or less. This is judged by a suitable qualified practitioner. Mentally ill persons is a specific legal term that is defined as individuals with mental illness and who are at risk of harming themselves or others. In 2014, Australia's chief psychiatrist interpreted the harm clause to include emotional, psychological, physical, financial harm, as well as predatory behavior, self-harm, neglect, violence, aggression, and harm to the reputation of relationships. Mentally ill persons usually have a condition of sustained, continued deterioration, and the condition seriously impairs an individual either temporarily or permanently. Serious symptoms include irrational behaviors like hallucinations, delusions, psychosis, as well as severe mood disturbances, and includes drug-induced symptoms. Mentally disordered persons is another legal term which refers to individuals displaying irrational behavior and having significant physical risk to either self or others. The definition is different to the previous term, since all mentally disordered persons are mentally ill persons, but not all mentally ill persons are mentally disordered persons, since mentally ill persons involve individuals who have or previously had a mental disorder. Admissions. These are when people are placed into proper care. It involves scheduling, which is defined as when medical practitioners fill out a schedule slot for patients to receive treatment. This is carried out by ambulance and police officers, and admissions are only valid for 5 days in the patient who is mentally ill. Admissions require the forensic patient to be at risk of harming self or others and may sometimes coincide and corroborate with criminal investigations. Admissions can be made by designated primary carers or even family or friends for individuals who live in remote areas, and requests must be lodged in written form to medical superintendents of hospitals. Admissions can be made by court order, and this brings about the need for relevant scheduling. Admissions need to retain confidentiality, at least as much as possible, and once detained formally, the process is different to getting out. People who are mentally disordered can be detained for 3 days and must be examined for 12 hours of admission, and subsequently every 24 hours. The second examination involves a mental health inquiry and a tribunal as soon as possible. Individuals need to be discharged if they no longer have a mental disorder. Mentally ill individuals can be detained for 3 months and must be examined within 12 hours of admission, whereby they have the same second examination involving a mental health inquiry by a tribunal. These patients can be recommended involuntary admission for up to 3 months or CTO for up to 12 months. Mental health inquiry requires legal representation of informally admitted patients unless otherwise requested. The minimum practicable level of medication is to be used until patients are seen by the tribunal. Patients must appear before tribunals in street clothes and can apply makeup and shave. Now I'll go through the previous changes to the Act. So changes in the 1990 Act in 2007 include adding the Statement of Rights when admitted, providing greater access to information for family and carers, and allowing ambulance drivers to formally admit patients. Also, 2 different types of CTOs were collapsed into one category. Changes in 2017 to the Act include emphasizing the obtaining of consent, integrating the active involvement of carers, and an increased emphasis on personal recovery. Also, within the Health Practitioner Regulation National Law Act 2009, or otherwise known as National Law, Section 30 as to registered health practitioners. Practitioners, employers, and education providers must meet mandatory notifications, which are obligations made by the Australian Health Practitioner Regulation Agency, AHPRA, in regards to conduct, impairment, and health of the practitioners themselves. National Law S140 specifies notifiable conduct to be practiced amongst practitioners when they have engaged in drug or alcohol intoxication or sexual misconduct. Basically, practitioners must notify the legal organization of the AHPRA if other practitioners engage in either unlawful or unprofessional behavior. Thus, notifiable conduct involves anything performed by practitioners that may harm the professional standard. Practitioners must also adhere to the Privacy Act of 1980 1988 involving following guidelines of the Free Australian Privacy Principles, APPS. These involve transparent, open managing of personal information, anonymity and using pseudonyms when appropriate, collecting solicited personal information, handling unsolicited information, notifying personal information collection, disclosing using personal information, direct marketing, oversees disclosure of personal information, using or disclosing of government information, maintaining accurate quality of personal information, security of personal information, ensuring that it is stored safely and cannot be modified nor disclosed. Access to personal information, Australian privacy principles ensure entry obligations need to be outlined when individuals request to access their own personal files unless specific exceptions apply. Also, there needs to be a correction of personal information whereby psychologists give preference to truth, correct notes, and fix inaccuracies. Finally, psychologists must retain good records since someone other than you might need good information to give treatment to individuals if you are not able to give it anymore. Good records serve as a good refresher used in case of relapse, is a good use of personal protection to ensure that people don't sue, and since the court works on evidence and record keeping, psychologists use these records and they need to be signed and dated. Records thus are necessary for client management. In summation, psychologists, clients, and society are restricted and simultaneously protected by many laws. We looked at the New South Wales Mental Health Act of 2007, informed consent, informal admission, formal admission, involuntary patients, forensic patients, community treatment order or CTOs, mentally ill persons, mentally disordered persons, admissions, scheduling, mentally disordered admissions as well as mentally ill individual admissions, mental health inquiries, changes in the 1990 Act, in 2007 and then subsequent changes in 2017, the Health Practitioner Regulation National Law Act 209, Section 30 as well as Section 140, notifiable conduct, the Australian privacy principles, and finally the need to retain good record keeping. Thanks for watching.